can't hold somebody. And I will put on the record. Any of our cases from that day.
All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call the docket. When I call your name and you hear it, say present here, raise your hand so I can bark you down. If I don't see you and hear you, I may bark out here, issue warrant. So it's very important that I hear you, okay? Joseph Aguado. Joseph Dan Aguado. Grayson Berry is verified in custody in Dallas County. We'll recall that case. Ernest Bowie, indicates that he has a medical procedure today, and the court has confirmed that. We will recall that case. Houston Carpenter. Tavares Dixon. Here. Vincent Freeney. Is Vincent Freeney here? For the record, Cody Eugene Gates, Mr. White has filed a waiver of arraignment that's been approved and pretrial has been set on January 6th. Dennis Ray Jones. Heather Keels. Keels. Heather Lynn Keels. Michael Welch. Michael Chase Welch. Cody Wheeler. Bryce Carroll. Cameron Roberts. Hannah Hodge. Randy Lanfrey. Randy Foy Lanfrey. Tad Michael Russell. Tad Michael Russell. Billy Fleming. Make sure you say your name or say here present. Talia Powell. Here. Jonathan Curtis. Here. Janet McGuire or Janet McGuire. Joseph Simpkins. Here. Braxton Henderson. Here. Damon Jackson. Here. Ralph Hanselka. Misty Backus. Misty Lynn Backus. Giovanni Chavez Rosales. Thank you, Mr. Randy. Tony Scott. Tony Anthony Scott. For the record, Billy Allen, CR 21-318, waiver of arraignment has been filed and approved with pretrial set November 30th. Tyler Donica. Christopher Neasley or Nisley. Brianna Rogers. Sarah Potter. Travis Skinner. James Bustamante. Brittany Hamilton. Joshua Hand. Joshua Ray Hand. Okay, thanks, sir. Jason Hodebeck. Charles Howard. Leonard Purley. John Pickney. Antonio Lano. Jason Barney. Mandy Jones. Ray Moore. Ray Moore Jr.
Your Honor, I spoke yesterday.
James Norris. James Roland Norris.
There's an over to you guys. Have office contact. I have talked.
Edward Woodall, Marcus Gardner.
It's at 11, Judge.
Oh, great, thank you, Mr. Roy. All right, is there anyone whose name I have not called that's present in the courtroom? Your name has not been called. All right, counsel, if y'all want to form a line over here, let me know who's ready. Dwight, ready?
I'm ready for this report.
If he refuses the misdemeanor, he can just take a conviction, but it's a misdemeanor. Or he can work it out and defer it to the third.
Mr. White, who do we have here?
Mr. Woodall.
All right, this is cause number CR 21255, State versus Edward Earl Woodall, set for pretrial.
Your Honor, we don't have any contested free trial right now. Talking to Ms. Heisel about this. We'll abide by the court's standing discovery order, ask the court to move this over to Docket Hall.
All right, are you available on December 6th, Mr. White?
I'm sure I am.
All right, court sets Mr. Woodall then for docket call 9 a.m. on Tuesday, December 6th. I believe that's a Tuesday. I'm sorry, Mr. White, that's not right. Be either December 14th or December 16th. 14th is a Tuesday, 16th is a Thursday. Less on Thursday.
Let's see.
All right, December 16th, Mr. Woodall.
Matt,
Yes. All right, Ms. Hodge is set for arraignment.
That is correct, Your Honor. She has seen her indictment, understands what she starts with. Her name is correctly spelled in the indictment. She wishes to enter a plea of not guilty at this time.
All right, the court will enter Ms. Hodge's plea of not guilty into the record. Court will set Ms. Hodge then for a pretrial hearing on, you prefer December 14th or 16th, Ms. Beasley?
Your Honor.
All right, Ms. Hodge, you're ordered back before the court on December 14th for pretrial.
Yes.
Once you sign and get the yellow copy, you'll be free to go.
Deb, what was the date on that? Thank you.
Any whereabouts known on Landfree or Russell?
On Landry, Your Honor, he was set in the Misdemeanor court last week and did not make an appearance there. I have not heard from him in a few weeks.
All right. Is Tad Michael Russell here? All right, court will issue judgments nice eye in these cases for both those individuals.
Thank you, Your Honor.
Thank you, Ms. Beasley.
I will be around, Judge. I have court this afternoon, so I'm working on plea paper.
Okay. All right, who's next? Ralph Hanselka, CR 21, 169 and 170. All right, Mr. Hanselka is set for docket call and he's charged.
Yes, Your Honor, and we spoke to the prosecutor yesterday, late in the afternoon, and I think we have a plea deal that's gonna be agreeable. We just need some more time to talk to our client and to get.
So it will be for a time offer. What is the offer? 5 to 2. Stating any objection to resetting this for an additional docket call?
No, Your Honor.
We set it for docket call or are we setting it for plea?
I think it's okay to go ahead and set it for plea as long as we don't need to waive anything to do that. That was my understanding, Judge, that we would move forward to plea. We did discuss getting a waiver of jury trial. If they weren't willing to do that at this point, given that this is our first setting for plea, I have no objection.
Okay. All right, court will reset Mr. Hanselka for docket call / plea on, are you available December 14th or 16th?
Is there any way that we could move into January? I have a trial set on.
State any opposition to resetting it past?
Judge, was the reset request on behalf of the attorneys or on behalf of Mr. Hanselka? Okay, no objection.
All right, January 6th. All right, Mr. Hanselka, once you sign this and get the yellow copy, you'll be free to go. You're due back January 6th at 9 a.m. Sir.
Good morning, Your Honor. Mark Carter for Billy Fleming.
CR 2119, Billy Carl Fleming, Jr. Show Mr. Fleming is set for docket call.
Yes, Your Honor, we have one other issue. At the prior hearing, we had an issue in regards to Mr. Fleming is supposed to repay the county for court-appointed attorney's fees. And the court looked at the bill submitted and said that higher than initially, or that it should be. So we've been checking back with the district clerk's office, but we have not yet got a new bill in order to satisfy that requirement. I think you said that he.
I recall, yes. So what's the announcement as to a docket call?
Your Honor, we just confirmed the offer today. I need to go back and check with Anderson County to see if they would proceed forward or not proceed forward. Talked to the district attorney's office. They did not object to resend it for one more docket call to see where we're at or what we're going to do.
So we're at the second docket call now. So is the offer changed? Is the offer stayed the same?
Judge, Mr. Cargill's new counsel, I believe this is only his second setting. And he wanted to confirm with me what the offer was, and that was just done this morning.
It's different than what was expressed by the previous counsel. So
All right, court will reset Mr. Fleming for docket call on either the 14th or the 16th of December. Which one?
the 14th is fine.
All right. Mr. Fleming, you're ordered back December 14th at 9 a.m. Once you sign the notice of setting, get the yellow copy, you're free to go.
Did you want to address the other issue, or do you just wait?
We'll just wait. We'll just
Thank
wait.
you.
I'll have my indigent defense coordinator follow up with his previous counsel. So we can't see if we can get that number straight for him.
And after I finish this, I'm free to go.
Yes, yeah, white copy stays here with us, yellow goes with him.
Thank you.
Good morning.
Chester, very brief this morning. Jonathan Curtis, Joseph Sinkins, would like to take a first.
Talia Powell, CR 21306 for arraignment.
Spelling of the name and indictment is correct. She understands the charges that she's sending with advancing county at this time.
All right, court will enter Ms. Powell's plea of not guilty into the record. We'll set this for a pretrial hearing. Do you prefer December 14th or 16th, Ms. Chester?
14 is
All right, Ms. Powell, the court's going to set you for pretrial hearing on December 14th at 9 a.m. Once you sign and get the yellow copy, you'll be free to go. Jonathan Curtis. Cause number CR 2121020211192 set for docket call.
Yes, Judge. We have confirmed with the Attorney's office this morning. We'll be asking for another docket call. There is an offer on the table. I confirmed some nuances with the offer this morning, so I just need to respond to my friends.
Any objections from the state?
No, Your Honor.
All right, court will reset Mr. Curtis for an additional docket call on December 14th at 9 a.m. Once you sign and get the yellow copy, Mr. Curtis, you are also free to go. Yes, sir.
What's a nuance? Is that a new?
Janet McGuire. CR 18492 set for motion to revoke.
I believe that's it. Oh, it was, yes, Your Honor. I spoke with Ms. McGuire. She understands the allegations in the motion to revoke. We were able to come up with some good practice. Don't have any paperwork on her right now, but it's our understanding she's being true to those allegations.
We're doing that today.
If I haven't sent her one o'clock, but I know that it was originally sent when she was in jail. And so I think it was moved to this morning, so we are aware of it.
And do we plan on pleading true and doing that today?
Judge, this is Mr. Woodwike's case. I do not believe that he had paperwork prepared on it. I'm unsure if that's done.
Ms. Chester, was she going to plead true and for revocation in time or to be placed back on community supervision? What was your agreement?
I do not have an agreement from the state.
Oh, I'm sorry. I thought you said that you didn't have any paperwork, and I thought you were saying you didn't have any plea paperwork on it.
No, I have not received anything on that.
Discovery wise. Okay.
All right, the court's going to set Ms. McGuire then for, what I'll do, Ms. Chester, is I'll set her for a contested hearing on December 2nd. And if you all come to an agreement, y'all can enter that in on the 2nd. If not, then we'll go forward with a contested hearing on that day.
Yes, Judge, and is that at 9 a.m. as well?
As long as she's on bail, it'll be at 9. If she's ever in jail, it'll be at 1:30. Ms. McGuire, I want you to report to your probation officer the day before you leave.
Yes, sir. I have an appointment at 9 or after.
All right, once you sign and get the yellow copy, then you can report to probation. Joseph Simpkins, CR 21245. All right, Mr. Simpkins, set for pretrial.
Yes, Judge, that's correct. There was actually an issue with discovery. No, a lot of the data drops just came blank distance. My office was just able to pick up the disk discovery, so I just need a little bit more time just to review that with Mr. Simpkins if we can get it.
All right, court will reset Mr. Simpkins for an additional pretrial on December 14th at 9 a.m. And once you sign, Mr. Simpkins, you're free to go. Yes, thank you, Ms. Chester. What, sir? Did you sign up to get back on the list? You haven't done that? I'll get right. Then get to the back of the line. I'll get back on. Call the next person. Mr. Donica? CR 21289. Mr. Donica is set for pretrial today.
Judge, we have no outstanding pretrial issues. If we could have him set for a plea, I'm confident that we can get that done.
All right, you available December 16th?
Yes, sir.
All right, Mr. Donica, the court's going to set you for plea on December 16th at 9 a.m. And I'm going to have your client sign conditions of pretrial release while he's on bail. So once you sign and get the yellow copy, then come back here and meet with these officers. They're going to go over your conditions of pretrial release, which means there's going to be conditions attached to your bail. In this case, you're going to have to report, drug test, do several things to remain on bail during the pendency of your case. Okay?
Yes, sir.
All right.
Just stack it on there.
Yes, you may. You have Mr. Jackson.
And I'm also here for Mr. Stucco on this too. I have key paperwork for him and I'm about to go over it after the file stamp for you.
Okay, so you just go ahead and call your client and you're going to do the plea.
Yeah, then I'll come back around for Mr.
Damon Jackson. I'll let you. This cause number is 2021-361, 362, CR 2122, CR 21173. Show that he is set for plea today. Is that right?
What's last time he was hospitalized? Last time he set up today. Let's say to give him two options. Set a low one today, and now we're ready to set a first.
given that just before he was on this, I stated that I'm opposed to allowing, I'm sorry, I don't believe I caught your name, his new counsel's request for a short recess so we can do the paperwork. We would be ready to do it today, but we don't have the paperwork, so we could have a short recess.
It's gonna be for time or probation?
Probation.
Probation?
Yes, sir.
Available on December 16th.
Morning,
That'd be morning.
Later on, I'm supposed to be in Smith County.
Is it all morning or just one case or?
It's two cases.
So even if we set you at 11 o'clock here,
There's a chance. Yeah, there's a distinct chance I can.
I don't want to necessarily delay it, but
Available the following day of the 17th and also the 13th. Before that,
yeah, that's okay. I'm giving you the only days that I have available. Let's set it December 16th at 11 and we'll see if you can get it done that day.
and if not, I might have some.
Okay.
I've already got some consequences.
Okay. So Mr. Jackson, I'm going to set you for plea on December 16th. We'll set that at 11 a.m. So your attorney can try to wrap up his business in Smith County and come over here. And even if you're here by 11:30, as long as we get the paperwork done ahead of time, you get that, go over it with your client, it won't take very long to do the pleas.
Did you get past it?
No, he needs to sign that, sign date, make sure you have all the preset dates on there, and leave the white copy with us. We'll get the yellow copy.
Was it December 13th at 11?
No, December 16th. All right, you're gonna work on the plea papers for Mr. Stockwell, you said, right?
Yes, I got it.
Mr. Manning? Mr. Chavez, CR 21283.
Initially, we're here for arraignments. Mr. Chavez, we've gone over the indictment, Henderson, the charge of consent. At this time, it states not guilty. His name is Will Craig.
All right, court will enter Mr. Chavez plea of not guilty into the record. We will set this for pretrial hearing. Are you available on December 16th?
Yes, sir, Judge.
All right, we'll set this for pretrial on December 16th at 9 a.m. Mr. Chavez, thank you for doing what you said you were going to do. You said you were going to hire an attorney. You did that. I appreciate you doing that.
And Judge, I would ask, I know some of the conditions of pretrial release that he's required to reimburse the county for appointed. It asks that we amend those conditions so that that requirement is no longer.
We'll make that note on the conditions of pretrial release.
Thank you, Judge. And at this time, I'm done with Mr. Chavez. I'm still waiting to hear back from Ms. Bacchus. She set her plea today, and I believe she will be here just happening this morning.
Okay, just let me know.
So, Mr. Cardinals. Yeah, we can follow up on that.
Yeah. So when we get it, we need to print it out and show it to them. and say, this is- this is- she's gonna do it. All right, Mr. Schmidt. Thank you, sir. Appreciate it. Are you ready? James Bustamante, CR 21-9, CR 21-281. Mr. Bustamante set for docket call.
Yes, Judge. Last time you recall, most of my cases today were a short reset and a vacation. So, Mr. Jason, Matters Administration to try to remedy some of the issues we got to. So, this one needs to make progress, but we're still waiting to hear back from the VA. So, we have to set for additional documents.
Judge, I would not have an objection to that. On the condition that should be new conditions of pretrial relief that were supposed to be resolved last time. I don't know how they didn't get resolved, but they didn't. So as long as they get taken care of, if we can confirm before we finally release them that they have been taken care of, then we can, we don't have objection to another reset. Okay, I've got confirmation. They have been taken care of at this point. State has no objection to a reset to allow Mr. Bustamante to continue working with the deferral.
Give you a little bit more time since you're dealing with the VA January 6th. So, Mr. Bustamante, you're ordered back on January 6th. Come on back here and meet with Ms. Burns. She's going to go over your conditions of pretrial release. And then once she tells you you're good to go, then you're free to go. Okay. Brittany Hamilton, CR 2170. Ms. Hamilton is set for docket call.
Judge, received the probation offer from the state. Ms. Hamilton is rejecting that offer. That's met this jury package.
Is it a straight probation or deferred offer? So you've counseled your client on what rejection of the offer means, and the court's policy about not taking a plea agreement after today.
She's aware of that, Judge.
All right, Ms. Hamilton, court's going to find that you have been offered deferred adjudication by the state, that you've rejected that, and the court's not going to allow you to enter into a plea agreement after today. You understand that? You've spoken to your attorney, Mr. Schmidt, about that. So you understand that if you ask for a trial, and that's what you're asking for today, I'm going to set you for trial. And when that trial date comes up, you decide you would rather have deferred than perhaps being found guilty and being sentenced or placed on straight probation, that I'm not going to allow you to enter a plea.
My mind's gonna stay the same.
Okay. All right, court will set you to begin your jury selection. We'll set that for December 6th. So Ms. Hamilton, on December 6th, you're going to report down to the basement of the courthouse. You won't report here. We'll be selecting a different trial. Mr. Smith's not going to be required to be here on those days. He won't be required to be here unless I send him a notice that your case is liable for trial. So you're not going to go to trial on December 6th. You're going to go in line and wait until your case comes to the top.
Yes, sir. Thank you.
Do you know if Mr. Hand made it? Yes. Joshua Hand, CR 21168. Mr. Hand set for docket call.
That's correct, Judge. I'm gonna ask for an additional docket calls. We received an offer from the state. However, moderately confident that we can resolve it, but Mr. Hand has been tasked with getting some mental health records from me that represented the DA's office. Makes it like this. Once again, short, working on it. We'll be having those records.
State, you have a position.
Judge, if the defense has records that would be helpful to our determination in resolving this case, state has no objection to giving the defense time to procure those records, present them to us, and reach a fair resolution.
Available December 16th, Mr. Schmidt.
Vacation.
All right, court's going to set Mr. Hand in for a docket call on January 6th at 9 a.m. Charles Howard, CR 2176.
Each one. Which defendant?
Mr. Howard set for docket call.
That's correct, Judge. Mr. Howard, last time disposition on charge. It's a similar charge.
We have received them, but they have not yet been indicted.
It's not a judge, we've asked it to be set for additional calls so that we can resolve all these issues.
All right, court's going to set Mr. Howard for docket call on January 6th. Mr. Howard, hang on just a second. Mr. Schmidt, I show that Mr. Howard's still delinquent on his pretrial release fees. Mr. Howard, are you making a payment on that today?
Yes, sir.
How much are you paying today?
Well, I mean, I'm been struggling a little bit. I've been paying for two, and me and
I know, I just said, how much are you paying today?
40 apiece, probably.
How much?
40.
All right, you need to go ahead and move over to the probation department and make that payment today.
Yes, sir. Yes.
Leonard Burley, CR 21234. Mr. Burley is set for pretrial.
Great, Judge. We have been contesting the trial. That's not accepted.
All right, court will set Mr. Purley for docket call on January 6th. Mr. Burley, I need you to report to pretrial release so that you can sign your conditions of pretrial release. They're in the course. Mr. Burley, you can just go ahead and have a seat right here, and then whenever she gets back, she'll take you in there and y'all can sign. John Pigney, CR 21184. Mr. Pigney set for docket call.
That's set for a plea on the January 6th.
That be to time or probation. All right, court will set Mr. Pigney then for plea on January 6th at 9 a.m. Mr. Pigney, once you sign and get the yellow copy, you're free to go. All right, so you work with, you said plea, Mr. Hodebeck.
Well,
All right, Mr. Sanders, are you ready?
and I. For Sarah Potter. Doing good. All right. Doing good for Tuesday. Sarah Potter, CR 21-138. All right, Ms. Potter, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir.
All right, you may put your hand down. Your name is Sarah Ann Potter, is that right?
Yes, sir.
Ms. Potter, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
I am.
You feel like you've had enough time to discuss the case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes, sir.
Mr. Sanders, do you believe Ms. Potter to be competent today?
Yes, sir.
And have you explained to her her legal and constitutional rights?
Yes, sir.
And you believe she understands them?
Yes, I believe she does.
The plea agreement is that Ms. Potter pleads guilty to driving while intoxicated with a child under 15 years of age, a state jail felony, which carries a range of punishment of not less than 6 months or more than 2 years and a fine not to exceed $10,000. For the recommendation that her sentence be set at 2 years confinement in the state jail division, suspended with her being placed on probation for 3 years with a $1,500 fine, court costs, and reimbursement fees. Is that your understanding, Mr. Sanders?
Yes, sir.
And yours as well, Ms. Potter?
Yes, sir.
That's what you're asking the court to approve today?
Yes, sir.
Okay, so you understand the range of punishment, as I stated it, and you understand the plea agreement. Understanding both those things, then how do you plead to driving while intoxicated with a child under 15 years of age?
Guilty.
Are you pleading guilty to that charge because you are guilty of committing that charge?
Yes, sir.
Has anyone forced, threatened, made you feel like you had to plead guilty to this charge? All right, the court will accept the defendant's plea of guilt. Mr. Sanders, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Ms. Potter, based on my review of the evidence, I do find enough evidence to convict you of this offense. The court will follow the plea agreement in your case. Court convicts you of driving while intoxicated with a child under 15 years of age. Court will assess your punishment at 2 years confinement in the State Jail Division of TDC. Court suspends that sentence, places you on probation for 3 years, orders you to pay a $1,500 fine, $735 reimbursement, $290 court costs. Ms. Potter, have you ever been on probation before?
Yes, sir.
Did you complete it or did you get revoked?
Got revoked.
Was it a misdemeanor or a felony?
A misdemeanor. Oh, a felony.
Felony, so you had to go to prison?
Yes, sir.
How long did you go to prison?
Almost 3.5 years.
What was that for?
Burglary.
Burglary? Is this time going to be different?
Yes, sir.
And why is that?
Because I'm sober now and that makes a big difference, I would think.
How many kids do you have?
3.
3. Have you ever lost a child?
No.
You never had a child die?
Lost.
Yeah, have you lost? Have you ever had a child that's died? No? I've lost a child. I know others have lost children. And I've seen people come in here and do what you've done in this case and kill their kid. And I can't tell you the agony that you feel as a parent when you lose a child. And I hope that you're sober and hope you're making better decisions now. So I'm telling you, that's a sentence that you'll live with the rest of your life. You'll go to bed thinking about it. You'll wake up thinking about it. You're lucky. You're so lucky that the police officer pulled you over and arrested you and put you in jail, and that the DA's office indicted you, brought you here today. You may not feel lucky today, but I'm telling you, you're lucky because you could have easily just kept on driving, had a crash, and killed those 2 kids. All right, so your sentence has been assessed today. So ball's in your court. You're either going to comply or you're not. If you don't comply, then you go to prison for how long?
2 years.
And it's day for day, no parole. Understand? All right, Ms. Potter, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department. So they carry out the terms and conditions of the sentence. I'm going to have you step over here with the bailiff to be fingerprinted. After that, I want you to go to the probation department to do these doors. You ready up, Mr. Skinner?
Yes.
Travis Skinner, CR 2226, CR 2065. Status update on the blood examination.
Yes, Judge, the blood toxicology did come back. However, we are still waiting on the DNA lab, which was ordered by this court. We have requested expedited analysis. We have been approved for that. They tell us we will have it by December 1st. My experience with them means we hopefully will have it sometime in January. So I'm going to ask for the January 6th setting date. I think last time we went to every 60 days for Mr. Skinner's benefit because he is following, as far as we're aware, all of his pretrial release conditions, and we are just waiting on the state lab.
Are you available on January 6th?
Yes.
All right, court sets Mr. Skinner for another status on January 6th at 9 a.m. call you have, Mr. Sanders?
Yes,
Do you have anything on the afternoon docket?
I do have.
You're not free to go then.
I know.
Hey, but neither am I.
Try to appear by Zoom. I've got to court with Wood County also.
Okay. So that's not work. Ms. Chester. CR 17-442, Houston Scott Carpenter. All right, Mr. Carpenter, the court has reviewed your request for a court-appointed attorney, finds that you do meet the legal requirements for court-appointed counsel. Honorable Casey Chester has been appointed to represent you. Ms. Chester, have you had an opportunity to meet with Mr. Carpenter today and go over the indictment?
Yes, Your Honor, I had to understand that he was able to look at the indictment, understand the charges, and was confirmed to me that all the names on the indictment are spelled correctly, and at this time, we would enter a plea not guilty.
All right, the court will enter Mr. Carpenter's plea of not guilty into the record. We will set this for pretrial. Got you coming back on the 14th, but I can give you more time. I can maybe get it January if you need more time.
That might be safe, just so I can get all the discovery.
All right, the court's going to set this for January 6th for pretrial. And Mr. Carpenter, I'm going to order that you be placed on conditions of pretrial release. So after you sign this with Ms. Chester and you get the yellow copy, then I want you to report over to Ms. Burns. She's going to have some additional paperwork for you. You're going to have to report, you're going to have to drug test, make payments towards your court-appointed attorney while you're on bond. Did you send him around? Mr. Yeah, just come on around this way. Mr. Knoll. Let's do Brianna Rogers first. Are you ready, Ms. Rogers? Brianna Rogers. CR 21-236.
Good job, Ms. Rogers. I got a phone call. Short version is, she asked me if I work for her in county. I said I work for myself. I represent her. It's a discussion about what position under the penal code and under the health and safety code means exactly. She indicates she may hire a lawyer. I got a call today. I asked her what she's doing.
Ms. Rogers, you asked for a court-appointed attorney, and Mr. Knoll is a licensed attorney in the state, and court has appointed him to represent you. Are you going to hire an attorney to represent you?
Yes, sir.
How come you haven't already done that?
I haven't had the money.
And so, do you have the money now?
Yes.
Okay. And when are you going to have the attorney hired?
By next week.
Okay.
Is that the appropriate papers? Because I've had a problem with that recently for 5 was today offer of information and also offer of time.
Are you available on December 16th, Mr. Knoll? You will? Okay. All right. So what I'm going to do, Ms. Rogers, is I'm going to reset you for a docket call on December 16th. And we're going to set that also for status for your new attorney. So whenever you hire the new attorney, you need to tell them they need to file a motion along with order to substitute counsel. They need to put Mr. Knoll and the court on notice. So they need to file that, so we'll know who the new attorney is. Okay. All right. I want you to report to pretrial release. I show that you failed to report in October. Is that right?
I didn't. There was nobody in the office whenever I went there.
All right. Then I want you to come over here and report. report here, and then after the report, then we should have a seat out here until we get a result. All right, can the state, Mr. Knoll, can you approach? All right, this is cause number CR 21174, State versus Christopher Neasley. All right, it's my understanding that there is a plea agreement worked out in this cause. Is that correct, Mr. Knoll?
It is said that all the plea papers have been executed and checked, so.
Mr. Neasley, my records reflect that there is an open warrant for your arrest at this time. So I'm going to have the deputy take you into custody at this time. No. Mr. Neasley, ordering you into custody. Mr. Knoll, since Mr. Neasley has his new charge, I don't I don't want to go forward on this current case, so what I'm gonna do is we're gonna reset that. We'll reset that to January 6th. We'll check the status.
That's obviously, it's interesting. Thanks.
Agreed.
Thank you, Deputy Phillips.
Saves and Bob need to plead guilty. So that should get you there. Just wanna make sure. I need his driver's license number here. Make sure that that's his current address. That's where I had as of the date of arrest. So if that's not correct, we would just want to do that correct.
So, are you good?
I believe so.
Andy Jones, CR 2197. Why has Ms. Jones on over her conditions of probation? Can you have her sign it? All right, Ms. Jones, if you'll raise your right hand, I'll place you on the oath. Ms. Jones, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Mandy Jo Jones, is that right? And Ms. Jones, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Been diagnosed with PTSD and manic depression and bipolar.
Are you currently on medication for those? Are you undergoing any type of treatment, mental health treatment?
I'm not in, it's been a while.
Do you feel like today that you have rational understanding and thoughts to understand the proceedings as they're occurring today?
Yes, sir.
And in this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed that you do not understand?
No, sir.
Mr. White, do you believe Ms. Jones to be competent today? Can you give me kind of statements regarding her mental health, or
Your Honor, she's not.
you haven't seen
I
any?
need some information.
Thank you, Mr. White. Ms. Jones, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. That carries a range of punishment of, if convicted, of not less than 2 years or more than 20 years, confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that full range of punishment? If the court approves the plea agreement today and places you on deferred community supervision, if later I find that after a motion from the state indicating that you violated your conditions of community supervision, if you're brought back before the court and the state proves that in hearing, and the court could adjudicate your guilt, that means find you guilty, and then the court could revoke your community supervision and then assess punishment anywhere from a minimum 2 up to a maximum of 20. Do you understand that?
Yes, sir.
Understanding that, you still want to go forward with this plea? All right, Mr. Woodwine, I'm looking on the judgment here. It says that there would be a finding on the deadly weapon. I believe if I make a finding today that there was a deadly weapon used, I don't think that I can give deferred adjudication.
Yeah, I think they were trying to get around it by saying not a firearm, but I don't think that'll make any difference.
Yeah, I think if I make any finding that there's a deadly weapon, I think that then prohibits.
Well, I mean, Ms. Hyson was actually in that case. So she's in here.
Judge, I believe that's correct by law. I don't know anything about this case, but you are correct. There's a finding of a deadly weapon. We can't do deferred. Not sure. Judge, if I can excuse the finder.
If it's her case and she wants to talk about it.
Yes, Judge.
I'm sweating it. Oh, it scared me.
Just one moment. I've got. No. Sorry, I'm in the middle of a plea right now.
Judge, state would abandon the deadly weapon finding. I made the mistake of telling Ms. Abney it is our intention to proceed just on a deferred offer.
Okay, so what I would do is I would just white out this so that there would be no finding at this time, because later, if she is brought back for hearing,
At adjudication, perfect.
so I'll just wipe this out. Just ask you to make me another copy.
I'm sorry about that, Judge.
It's no problem. Just want to make sure before I.
Ms. Abney asked me in passing, and I wasn't thinking about the fact that this one was deferred, so.
Just right. I'll do that. All right, Ms. Jones, understanding the range of punishment for this charge of second-degree felony offense, aggravated assault with a deadly weapon. Has anyone forced you, pressured you, made you feel like you had to plead guilty to this charge today? So with that understanding, how do you plead to the charge of aggravated assault with a deadly weapon? Are you pleading guilty because you are guilty of that crime? All right, court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
No, Your Honor. After the reform judgment.
All right, Ms. Jones, based on my review of the evidence, I do find enough evidence to convict you of this offense. The court will follow the plea agreement in this case. The court will defer a finding of guilt, place you on 3 years community supervision, order you to pay a $1,500 fine, $290 court cost, $90 reimbursement fees. Jones, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted, and then what I'm gonna also order you to do is, you come on board. After you meet with probation today, they're gonna have this order. They're gonna give you a copy of it. I need you to take your ID, and I need you to go out to the Van Zandt County Sheriff's Office, and you need to be booked in. No.
Let you go.
Fingerprinting. Sorry, if you'll focus on me, I'll tell you what's going on. You start looking around, so that's fine. You were arrested outside of Van Zandt County, right? You weren't arrested in Van Zandt County, right? You were arrested. Well, they're telling me that they don't have your fingerprints, so I want you to go
Like I
out.
said, Judge, we don't quite understand because we're on bond.
Yeah, I don't know either, but I want you to go out there, take this order to them, take your ID, and let them figure that out, okay? So they're not gonna change you out or anything, they're just gonna look for your fingerprints. Okay, still waiting on that. Are we ready on Mr. Lano? CR 2134, Antonio Lano.
A lot of paperwork on this one. It is a chapter 62 offense, so there's also a protective order. Sort through everything, get it in some semblance of order. Oh, I need your signature here. And I have the protective order to submit after the plea, Judge.
And that's this right here, right? You have an agreed order, please.
Yes, Judge, I do. That's just
This
the
order setting
hearing.
hearing.
Do you mind telling me the cause number on that, Judge?
Yeah, FM 2152.
FM 2152.
52. Chapter 62 stuff.
Judge, I believe a copy was given, that they've already given us chapter 62.
Yeah, here's the admonishments.
Okay.
They were behind the conditions.
And then I'm also going to.
She looks like she's gonna wrap it on us this morning.
Let's try it. I would have a nervous bladder too if I had a warrant for impersonating a police officer.
I'm in the middle of a plea. After that, I'd be happy to, you need to get behind Miss Beasley. I think she's next. Probation information.
Say that, Judge.
It's not a thorn of probation offer may change.
Yeah. Well, the assault on my violence, you have the excuse of she's crazy too, but.
I'm gonna change my opinion.
We're gonna have to have that conversation again. Thank you, Jeff.
Miss Eisel, this Mediola here.
Your Honor, she is not,
Just gonna mark this out.
Yeah,
Says she
you can
appeared in
just
person.
mark her, yes, state's applying on her behalf.
All right, Mr. Lano, I need you to raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. Your name is Antonio Lano, is that correct?
Junior.
Junior?
Yes.
And Mr. Lano, are you a United States citizen?
Resident.
Resident, your lawful permanent resident?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you were represented by your attorney, Mr. Paul Stuckel. Do you believe that you've had enough time to discuss your case with him, have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read, signed today that you do not understand? All right, counsel, do you believe your client to be competent today? And have you explained to him the advantages and disadvantages of a deferred adjudication plea along with his legal rights? Do you believe he understands it?
Thank you.
Mr. Lano, you are charged by indictment with a first-degree felony offense of aggravated sexual assault of a child. However, the court finds that you've entered into a plea agreement with the state of Texas to a lesser third-degree felony offense of indecency with a child by exposure. A third-degree felony offense carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and carries a fine not to exceed $10,000. What that means for you, Mr. Lano, is if I approve this plea agreement to put you on deferred community supervision for a period of 8 years, if during that period of probation you violate any of the terms and conditions of your community supervision, the state could file a motion to adjudicate your guilt. That means to convict you. And they can request the court to revoke your community supervision. And they could ask the court to assess your sentence anywhere between 2 years to 10 years. You understand that?
Yes, sir.
So understanding the range of punishment and the plea agreement in which you will be placed on 8 years community supervision, you'll be ordered to pay a fine of $3,500, court costs of $290, and reimbursement fees of $40. Understanding all of that, you still wish to move forward with this plea today?
Yes.
Mr. Lano, how do you plead to indecency with a child by exposure?
Good.
Are you pleading guilty because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty today?
Sir.
You say no? Okay. Court will accept the defendant's plea of guilt. Is there any objection to the admission of state's evidence?
There's not.
State's evidence is admitted. Court does take judicial notice of the defendant's judicial confession. Anything further from state?
Your Honor, let me double check. I do not believe that we have a victim impact statement on this, but before we proceed, please allow me to check that. That's correct, Your Honor. It was provided in compliance, however, it has not been returned.
And do you know if the victim is supportive of this plea?
Yes, Your Honor.
You know where she is?
Your Honor, the specific terms of this plea have not been discussed with her. However, my last meeting with her resulted in the plea agreement for the lesser included. We are confident that she would be in support of a lesser included plea, Your Honor. Your Honor, may we approach?
You may. Mr. Noel?
That's not a case that was eventually declined and just,
Gotta have the declination letter from
I'll get it.
the DA's office to go with it.
They never, in fact, that's what we were, took us a while to get it.
Yeah, you can ask, they can probably print you one today. Yes, sir. All right, for the record, cause number CR 21279, State versus Grayson Berry. Mr. Berry is verified in custody in Dallas County. Court's going to reset Mr. Berry for arraignment and status on January 6th. Cause number CR 16232, State versus Ernest Bowie. Mr. Bowie set for motion to revoke. He has been confirmed to have a medical procedure today. Court's going to reset the motion to revoke hearing until December 16th at 9 a.m. Tavares Dixon. All right, Mr. Dixon, we reset you last time for you to hire an attorney. Did you hire an attorney?
May I orally motion the court to appoint an attorney?
I believe that you requested a court-appointed attorney at our last sitting, didn't you?
Well, I called the district clerk and I let her know the unemployment stopped right before that time. And that's what I was referring to. And that's what I was living on at the time.
Then you need to go down to the end of the hall and see Ms. Tabraham, the indigent defense coordinator, and tell her you want to apply for court-appointed attorney, and you need to fill out all the paperwork, and it needs to reflect your income, your assets, your debts. So go down to the end of the hall and do that, and I'll recall your case. Is Benson Freeney here? All right, Mr. Freeney, the court, as you said, for a sanctions court hearing, show that you're behind in your payments to probation, you're behind in your collections payments, and you're behind in your community service. You're on probation until May 20th of 2025 on a deferred adjudication for a second-degree felony 2 to 20, minimum 2, maximum 20. I show that in order for you to successfully complete your probation, you have to pay $110 to probation each month, $280 to collection. That's $400, and you have to do community service at 10 hours a month, every month, without missing a month in order to successfully complete your probation. Are you gonna be able to do that?
You said 10 hours?
10 hours of community service at $400 a month. You gonna be able to do that? Are you working? And where are you working?
Train.
Train. Also show that you still need to take a drug offender education class. So I guess what I'm asking you is, are we spinning our wheels and wasting our time, or should they just go ahead and file a motion or vote and let the attorneys for the state decide what they want to offer you? So if I reset you to come back on January, or actually if I reset you to come back on December 16th, you're confident that you can pay 110 towards your probation fees, 280 towards your collection, and have 10 hours of community service done?
Yes, sir.
All right, well, let's do that. I'm gonna. Have you come over here and meet with Ms. Burns. And she's gonna have this form for you to sign. We're gonna have you come back on December 16th at 9 a.m. And that's all I expect to hear about, your payment and your probation. 12/16. So. Mr. Shada, are you ready?
Yes, we are. I apologize. We're ready for test revocation here in Smith County. I notified the court on Friday.
Yeah, they let me know.
Thank you.
Braxton Henderson, CR 21289. We're set for pretrial today, Mr. Shada.
Judge, yes, right now we're still under review of the discovery. This is the first degree charge. Mr. Henderson said to meet with Dr. Proctor for an evaluation on January 12th, Judge. I do have a set form here with me today. And I'm asking the court to set this for an additional pretrial after Dr. Proctor's evaluation.
What's the evaluation for?
It's a mental health evaluation, Judge, in addition to for mitigation issues.
Is it a competency or sanity?
No, Your Honor, it's not a sanity. We're not, Mr. Henderson, not saying it's competence forward and litigation purposes.
State.
State has no objection to resetting until after the competency evaluation.
All right, court will set Mr. Henderson then for hearing on Tuesday, January 25th. That's all I've got.
It's February, Judge, just because I don't know how long Dr. Proctor's going to take in getting a report back unless he wants to come back to the announcement on that. Trying to get into this year. Unfortunately, Dr. Proctor's partner passed recently, so it's been created a backlog on with scheduling with current clients.
Mr. Henderson's on conditions of pretrial release.
Yes, he is.
Next available I would have would be February 8th.
That's fine, Judge.
At the court.
All right, court will set Mr. Henderson then for pretrial hearing on February 8th at 9 a.m.
Judge, when I get the notice.
He'll get the yellow copy and then the white copy will go here and he'll be free to go. You stayed on that table. Like they're in that business.
Just maybe excuse me.
Yes, thank you, Mr. Sharp. Mr. White, are you ready?
It's thanks, but thanks, Sam.
Jason Farney, CR 21-164. All right, Mr. Farney, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Jason Lee Farney, is that right? And Mr. Farney, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss the case with him and have all your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. White, do you believe your client to be competent today?
He is competent.
Can you explain to him his legal rights if you believe he's understood those?
I believe he is. Talking.
Mr. Farney, you were originally indicted with a state jail felony offense of possession of marijuana between 4 ounces and 5 pounds. I see here today that you want to enter into a plea agreement to plead guilty to a lesser included offense of Class A misdemeanor possession of marijuana 2 ounces to 4 ounces. Class A misdemeanor in the state of Texas carries a range of punishment up to 1 year confinement in the county jail and a fine not to exceed $4,000. Do you understand that range of punishment? I see the plea agreement is that you're going to plead guilty to that charge, Class A. The state's recommending that your punishment be assessed at 9 days confinement in the county jail, with you receiving credit for 3 days and having to serve the remaining 6 days. In addition, you would have a $2,500 fine, $270 court cost, $180 restitution, and $35 reimbursement fees. Is that your understanding of the plea agreement? And as a part of the plea agreement, you're also going to be serving your remaining jail time on weekends, beginning this weekend and next weekend, between Friday and Sunday. Is that correct? All right, so Mr. Farney, let me ask you then, how do you plead to possession of marijuana between 2 ounces and 4 ounces, a Class A misdemeanor? Are you pleading guilty to that charge because you are guilty of committing that crime? You have to say yes or no out loud.
Yes.
All right, court, and Mr. Farney, has anyone threatened, forced, or pressured you to plead guilty today? All right, court will accept the defendant's plea of guilt. Mr. White, is there any objection to States 1?
No.
All right, States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we would rest the motion.
From the defense? Mr. White, is Mr. Farney making payments towards any of his fines and court costs today?
Don't believe it's given that today.
And have you discussed with Mr. Farney that if he does not honor the payment plan, what happens?
Well, I have specifically told him that I guess it's probably realizes that if he does not pay for this, somebody will come give him a place to stay.
Mr. Farney, I'm going to approve this plea agreement today, and after I do so, you're going to be ordered to pay fines, reimbursement, court costs, all these fees I'm going to announce shortly. Your failure to set up a payment plan and or follow through that payment plan means the court's going to issue another warrant for your arrest. Understand? All right, the court does take judicial notice of Mr. Farney's judicial confession. All right, the court's reviewed the evidence, and I find enough evidence to convict Mr. Farney of this offense. The court will follow the plea agreement. Court convicts Jason Lee Farney of possession of marijuana greater than 2 ounces, but less than or equal to 4 ounces. Class A misdemeanor. The court assesses his punishment at 9 days confinement in the county jail. The court awards Mr. Farney 3 days credit for time already spent in jail on this cause. Court will order him to serve his remaining 6 days as outlined in Exhibit A, special order for commitment to jail. Court also orders him to pay a fine of $2,500, $180 restitution, $35 reimbursement fees, and $270 court costs. Mr. Farney, when you go to serve your jail time, it's important that you have 2 things. One, the order with the dates that you're supposed to be there, along with your photo ID. If you do not have a valid photo ID, they're not going to let you in the jail. They're going to report to me that you didn't show up with your ID in the order. Understand? All right, Mr. Farney, you hereby remanded to the custody of the Van Zandt County Sheriff to carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted, and I want you to stick around and get a copy of this order. Come on forward, be fingerprinted with the bailiff. Yes, thank you, Mr. White. Ms. Beasley?
Yes, Your Honor.
I'm going to stand in for the arraignment on Mr. Jones. Mr. Jones, Dennis Jones, CR 21328. All right, Mr. Jones, you have been indicted with a state jail felony offense of theft of property greater than or equal to $2,500, but less than $30,000. Court has originally appointed the Honorable Debbie Beasley, who's here in court with you to represent you. However, Ms. Beasley is going to be retiring soon and may not be able to stay on for the duration of your case. So the court has amended its appointment and is now appointing Mr. Logan Sawyer, who I believe already represents you on related cases in another court. Is that correct?
Yes, sir.
Okay. Mr. Sawyer is not here today. Ms. Beasley has, at the court's request, agreed to stand in for the purposes of arraignment. So we're just going to fix your identity, make sure that you know what you've been charged with, and then at the next court appearance, Mr. Sawyer will be here with you. You understand? Okay. All right. So, Ms. Beasley, have you had a chance to go over the indictment with Mr. Jones?
I have, Your Honor. His name spelled correctly in the indictment. He understands the charge, understands the punishment range is initially a state jail felony with 2 enhancements that are not state jail. It looks like he's looking at 2 to 20 as second degree felony punishment range. He understands that. This is standard plea of not guilty.
All right, court will enter Mr. Jones' plea of not guilty into the record. We will set this for pretrial on January 6th. We'll send notice to Mr. Sawyer. And you should go ahead and contact Mr. Sawyer about this case as well. I need him to sign conditions of pretrial release for this charge. So, well, I want you to go ahead and get your yellow copy and then come back here and meet Ms. Burns to make sure.
Judge, may we leave Judge on Mr. Lane?
back on the record, calls number CR 1346, Texas versus. Right, the court has reviewed the evidence in this case. The court finds that there is sufficient evidence of the charge. Will follow the plea agreement on the recommendation of the state of Texas. The court hereby defers the finding of the charge. Offense of decency with the child by inspector. Court places Mr. Mono for community supervision for a period of 8 years. Orders him to pay a fine of $3,500, $290 cost, $40 reimbursement. Court also finds that the defendant has been prosecuted for a crime that in case chapter 62 of the Texas Code of Criminal Procedure. Court finds that Mr. Mono has been provided a copy of chapter 62. Supplemental acknowledgements of sex offender registration requirements, sex offender experience. Court is also, with regards to possible FM 21510, court finds that the state of Texas has filed an application for protective order. Court finds that Mr. Lano has been given notice of that. Mr. Lano is also represented by counsel on that matter and has entered into an agreed protective order regarding the victim of this case. Court hereby finds that all requisites of law have been met for the granting of a protective order. Court hereby orders the defendant under the protective order to he is immediately prohibited from communicating in any form or fashion with the victim and named applicant in a protective order, except through attorney or a person appointed by the court, from going within 200 yards of the person of the victim, an applicant of this cause, or going within 200 yards of the residence of the victim, or going within 200 yards of any place of employment, business, or child care facility or school of the victim. Mr. Lano is going to be subjected to the additional orders of the court as found in the protective order. The court has also modified the conditions of community supervision to require that Mr. Lano not go within 200 yards of the victim's person or residence. So what that means, Mr. Lano, is if the victim, through her relationship with her mother, comes to your house, you are not to be there. Understand? That would be a violation of your community supervision. Okay? So you're not to be within 200 yards of her at any time. Right? So if she's brought to your house while you're enjoying watching TV on a Sunday afternoon and she's there, either she has to leave or you have to leave. But at no time, under any circumstances, are you to be within 200 yards of her. You understand? Failure to abide by the order of the court would constitute a violation of your supervision. All right, Mr. Lano, the court hereby remands you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted by the bailiff. After that, I want you to report to Officer Maturi here with the probation department. You're welcome, sir. Yes, sir. Sorry. I put my head back down and went back to work. Appreciate you being here.
Thank you, Judge. That's it.
You ready on motor vehicle? Still waiting for papers? Ms. Beasley, do you have anything else?
Yes, Your Honor, Mr. Russell is in the courtroom.
Tad Michael Russell. CR 21-339-340. All right, Mr. Russell is set for arraignment today.
Correct, Your Honor. I've been able to discuss Mr. Russell's case with him. We've gone over the indictment. He understands what he's charged with, the punishment range, as well as all of his legal rights. He wishes to enter a plea of not guilty at this time.
All right, the court will find that Mr. Russell has waived the formal requirements of arraignment. There's a plea of not guilty in each charge, and we will set pre-trial. Are you available on December 16th? I'll probably have you here on the 14th as well.
Both days should be fine, Judge. I realize there's several cases we have to talk about. This may be one of those, but I'm trying to get the DVDs and finish reviewing all this information before.
Okay, we'll set him on the 16th then, since we're nearing capacity on the 14th. So, Mr. Russell, you'll sign the notice and get the yellow copy. You'll be free to go.
Make sure Mr. Russell's also signed his condition of control and release. I know at one time they were unsigned. I'm not sure if that's what taking care of or not.
I believe he has. I know that Mr. Carl has said that he's sorry.
Okay.
So, Mr. Russell, you'll come up here, you'll sign this yellow copy, and then I want you to report to pretrial release. Make sure they've got all your paperwork, and then you'll be free to go, okay? Tad. Yeah, you can come over here. Yes, ma'am. I'll call you in just a minute. What kind of appointment were? Is Heather Keels here? Ms. Keels, I called your case at 9 o'clock and you weren't here.
Yes, sir. I was walking at 7:51. My ride didn't show up this morning.
All right, Ms. Keels, are you going to represent yourself on your possession of controlled substance charge?
No, sir. I'd like to get my recorded one and lawyer.
Okay, then you need to go down the hall to the left and speak with Ms. Taberham and fill out the paperwork.
Thank you.
Go ahead and do that, fill out the paperwork, and then return to the courtroom. Michael Welch here. Mr. Wheeler, you're free to go. Sorry. I didn't know, hey, if I would have known that sooner, I would have cut you loose. I thought we were just doing a sanctions update, so sorry, you're good to go. Do we have the result? Any update on Mr. Ashford? At the schedule? Is Tony Anthony Scott here? Misty Backus? Ray Moore? James Norris? Marcus Gardner? All right, you can stay right there, Mr. Gardner. We're waiting on Mr. Russell. Haven't seen him. Have you spoken with Mr. Russell today? Okay, they said he was on his way. Okay. All right, cause number CR 21236, State versus Brianna Christine Rogers. Ms. Rogers, I had you drug tested and Officer Ventura here indicates that you used methamphetamine and marijuana. So Ms. Rogers, you were aware that you were on conditions of pretrial release. You understand that the court's going to find your bond insufficient for violating conditions of pretrial release. If not, then you should be aware that you can't continue to use drugs while you're on charges for drugs. So I'm gonna find your personal bond insufficient and I'm gonna put you back in jail instead of you. I said, please don't use drugs. I understand.
Stand up.
Stand up. I'm taking you into custody at this time. Rogers, what did you expect was going to happen?
It was because I got something I wasn't supposed to.
Listen, don't say anything that could incriminate you or be used against you in court. But what did you think was going to happen if you're using drugs while you're on charges for drugs?
Sorry. Don't put me in jail.
Ms. Rogers, that's already been made. You can post bond and you can get back out and
Let's go.
Mr. Gardner. All right, this is called number CR 2162, State of Texas versus Martin. Gardner, raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth? So help you God.
Yes.
All right, you get your right. All right, Mr. Gardner, are you a United States citizen?
Yes.
And do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any kind of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Joseph Russell. Are you pleased with his representation of you?
Yes.
But you've had enough time to discuss your case with him and have all of your legal questions answered.
Yes, sir.
Anything about this paperwork that you've read and signed today that you do not understand?
Yes, I understand.
Anything at all?
Yes.
Russell, do you believe Mr. Gardner to be competent today? Yes. Can you explain to him his legal rights?
That's the facts of the case. Options are.
Mr. Gardner, you are charged by indictment with a third-degree felony offense of driving while intoxicated third floor. Third-degree felony carries a range of punishment of not less than 2 years or more than 10 years confined in the Texas Department of Criminal Justice and a fine not more than $10,000. I see here that the plea agreement you've recently stated is for you to plead guilty. Their recommendation is that your sentence be affixed. It said at 5 years confinement within that range of punishment, and that your fine be $2,500, which is also agreed. In addition, moving order to pay court costs, restitution, reimbursement fees, the state is dismissing a possession of marijuana charge. You would have 2 days credit towards your sentence for time that you spent in jail on this cause. Is that your understanding of the plea agreement?
Yes.
That's what you're asking for us to approve today? Yes. All right, so Mr. Gardner, then how do you plead to driving while intoxicated and third floor?
Yes.
How do you plead guilty?
Okay, okay, yes.
Plead guilty?
Yes.
Are you pleading guilty because you are guilty of committing that crime?
Yes.
Anyone threatened, force, or pressure you to plead guilty?
No, sir.
Or accept the defendant's plea of guilt? Mr. Russell, any objections to state's evidence? No, sir. State's evidence is admitted in accordance with state tradition. This is what the defendant should. Yes, sir. All right, the court's reviewed the evidence. I do find sufficient evidence to convict Mr. Gardner of this offense. The court will fall for the agreement to reach the state. We're hereby convicts Mr. Gardner of driving while intoxicated offense. The court assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institution Division. The court orders him to pay a $2,500 fine, $290 bonds, and $60 reimbursement. I'm sorry, $60 restitution. $35 reimbursement. Court takes into consideration under section 1245 DA 2023-1 possession of marijuana less than 2 ounces. It also awards Mr. Gardner 2 days credit towards his sentence, the time that he has spent in jail on this case. Mr. Gardner hereby remains in the custody of the Maintain County Sheriff's will carry out the terms and conditions of the sentence and have you come forward to be fingerprinted.
Morning, Judge.
About to send out a search warrant.
Yeah, I know. I'm sorry. Judge Rako called me and I had to do a U-turn. I apologize.
Yeah, we should go take Mr. Gardner with you.
Yes, sir.
See you.
Yes, sir. I have her. Camera.
Mr. Odebeck. Mr. Odebeck, right hand. Sir, do you swear that the testimony you give us will be today will be the truth, the truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Mr. Odebeck, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney. Are you pleased with the representation of you?
Absolutely.
Feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Anything about these cases, paperwork that you've read and signed, that you do not understand?
Not at all.
And Mr. Schmidt, do you believe Mr. Odebeck is competent today?
Yes, sir.
And you believe he understands his legal rights?
Yes.
Mr. Odebeck, counsel for CR 2120, died from a state jail felony, offense, possession of controlled substance, one gram. Matter of fact, in both charges, both cases are charged with the same state jail felony offense, both possession of controlled substance, one less than 1 gram. Each case carries a range of punishment, if convicted and sentenced, not less than 6 months or more than 2 years confinement in state jail, and fines not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
I see your plea agreement in each case is that you're going to plead guilty to each charge. The state's recommending that your sentence be assessed as 2 years confinement in the state jail, with each sentence being suspended and you being placed on community supervision for 4 years. And in addition to that, you would have $1,000 fine in each case, $290 court costs in each case, $180 restitution. And in one case, you have reimbursement fees of $705 and the other $55. Is that your understanding of the agreement?
Yes, sir.
That's what you're asking for to today.
Yes, sir.
I don't think it makes a difference. I noticed that one of the terms of the plea bargain, one says probate for 4 years. Does have the box checked off as being suspended. All right, Mr. Odebeck, then, understanding the plea agreement and the range of punishments in each case, how do you plead to possession of controlled substance less than 1 gram alleged to have been committed on November 3rd, 2020, and also January 25th, 2020?
Guilty, sir.
And are you pleading guilty to each case because you are guilty of each one?
Yes, sir.
Did anyone threaten, force, or pressure you?
Not at all.
Court will accept defendant's plea of guilty in each case. Mr. Schmidt, the objection to case one.
No objection.
Case one is admitted in each case respectively. The court does take judicial notice of the defendant.
Nothing further.
Mr. Odebeck, you've been on probation for,
Yes, sir.
did you plead it or did you revoke?
I got revoked and got sentenced to 7 months, but I got time served on.
Is this time going to be different?
Yes, sir.
Why is it going to be different?
Because I have a lot more at stake.
What do you have at stake? What's more important than your liberty?
My kids, my family.
Kids. All right, the board has reviewed the evidence and finds that there is sufficient evidence to convict Mr. Odebeck. The court will, in each case, convict him of possession of controlled substance of one less than 1 gram. The court will assess his punishment in 2 years confinement in the Texas Department of Criminal Justice State Jail Division. The court suspends both sentences and places Mr. Odebeck for 4 years of community supervision. The court orders him to pay $1,000 costs in each case. $705 in CR 2121, $55 reimbursement in CR 2172. Mr. Hodak, if you violate your community provision, state proves that hearing, what do you believe?
I'm gonna go to the state jail penitentiary
For how long?
up to 2 years.
Up to 2 years or 2 years?
2 years.
That's the agreement that you. Since it's already been set today, 2 years.
Yes, sir.
All right, Mr. Hodak, if I remain in custody of the Van Zandt County Community Supervision Correctional Department, so they three of the correctional conditions that says, I have step forward to be fingerprinted and social probation.
I think so.
State, I'll need you to sign this one. I also need you to sign Mr. Carter's.
Yes, sir.
Proceed with seven. Yes, sir.
Ms. Keels? This is cause number TR 21330. Ms. Keels, the board has reviewed your application for complaint attorney. Honorable Bill Stevens to represent you. Mr. Stevens is not here, so you have to reset your case. I have this notice of appearance form that I need you to sign. I have you come back to the board on December 16th at 9 a.m. That you sign here. Actually, what I'm gonna do is I'm gonna have you go with this paper and she can get your copy of these things. And she's gonna have to sign. It was, she's done with you. That's on this page. All right, so, this paper you can have you sign, so we'll give you a copy of that, and after you're done, it's your.
There's pending, Monday.
Yes, sir.
that phrase.
No.
30. The following names will be called and judgment not size issued: Joseph Aguado, Michael Welch, Randy Lamprey, Tony Scott, Misty Backus. All right, we will resume at 1:30.